Good afternoon, welcome. It's the season of the Supreme Court preview, and this is the Federalist Society version of it, and it's a very good one. This is also the season where you have two kinds of cases before the Supreme Court. They've granted perhaps 40 cases, some of them quite interesting, and you'll hear about them today, mostly. But also on the horizon are some real blockbusters that could really transform American life, including 7 petitions the justices will consider at their first conference of the new term on September 29th concerning the question of whether there's a constitutional right to same-sex marriage. And not far behind that, a challenge to another aspect of the Affordable Care Act, and perhaps also on the horizon, conceivably this term, affirmative action and abortion. So you have two things going on at once, as is so often the case with the court. We have today with us a very distinguished panel. I've never been to a panel that was not introduced as a very distinguished panel, but this one authentically hits that mark. With us today are Orrin Kerr, who teaches at George Washington, is quite plausibly to say the nation's leading expert on the Fourth Amendment, and it's a pleasure to have him here. He was a clerk to Justice Kennedy. Will Consovoy, a partner at the Wiley Rain firm, and a clerk to Justice Thomas. Virginia Seitz, who's recently gone back to her practice at Sidley and Austin after service as Assistant Attorney General in the Office of Legal Counsel at DOJ. She was a clerk to Justice Brennan. Adam White, counsel at Boyd & Gray & Associates, and well known to a lot of us as a frequent contributor on legal matters to the Weekly Standard, the Wall Street Journal, and other publications. Kerry Severino, Chief Counsel and Policy Director of the Judicial Crisis Network, and also a frequent voice in the media. She clerked for Justice Thomas. I should have introduced myself. I'm Adam Liptak. I cover the Supreme Court for the New York Times. What we're going to do is set up maybe a dozen different cases, mostly granted, a couple on the horizon, moving from panelist to panelist, with maybe just a little bit of exchange between us if someone has an insight, a dissenting view, something to add. Then a brief discussion among ourselves, and then we'll turn to your questions. And we're going to start with Orrin.
Great. Thank you, Adam, and thanks to the Federalist Society for the invitation here. I'm going to run through 3 cases in 5 minutes, so this is going to be really, really fast. Just introducing 3 cases, and we can, of course, come back to them later if you'd like. So one of the interesting cases this term, Yates versus United States, raising the question, which I know is on everybody's mind, which is, are red grouper fish tangible objects under the Sarbanes-Oxley law? This is a case involving a criminal statute that makes it a crime to knowingly destroy, alter, or mutilate any record, document, or tangible object. The question in the case is whether a tangible object means a storage device for some sort of record or document, or whether it means just anything that is an object that is tangible. And the facts of the case are drawing a lot of attention, I think properly so. It's involving an individual who allegedly or was convicted of ordering his employees on a fishing boat to throw back red grouper that were undersized, facing an investigation of civil violations of harvesting fish that were too small. And the question is whether the fish are tangible objects. It's really a statutory construction case involving how broadly to construe the Sarbanes-Oxley law. And I should also add that I joined an amicus brief on the defense side, arguing that the statute should be narrowly construed under the rule of lenity. So that's Yates versus United States. Alonis versus United States is the Facebook rap threat case involving a question of how to construe the interstate threat statute, Section 875C, involving punishing transmitting a threat. It involves an individual who posted on his Facebook status updates involving what could be construed as threats against his wife. He at one point threatened to go to an amusement park or go to a school and perhaps commit a violent act at the school. He argues that it was simply he was joking around. He's an aspiring rap artist, and in fact, during his status updates, he's talking about true threat jurisprudence and about what he's doing is all First Amendment protected. It's sort of an odd situation, very meta here. It's sort of what's a true threat of an individual posting about what is a true threat. The first issue in the case is whether there's a subjective intent requirement. If he thought what he was doing was not a serious threat, do you interpret what is a threat based on what a reasonable person would think, or is it what the individual subjectively believed? Kind of, can you have an accidental threat is the question. A big issue, I think, online, because you read something online and you don't know what the person was thinking. Are they really intending that as a serious threat, or was that just a joke? It can be hard to tell from the context. And then if the court construes the statute as not requiring a subjective intent requirement, the next question is whether the First Amendment allows that, whether it's the First Amendment prohibits a negligent threat statute effectively. So there's the statutory question, and then also the First Amendment question if the court does not resolve that case on statutory grounds. And I should add that I gave a very small amount of assistance on the defense side for that case. The last case I wanted to talk about is Hine versus North Carolina, a Fourth Amendment case involving reasonable suspicion to stop a car in which drugs were found. It involves a North Carolina traffic law that says you have to have an operating stop lamp. The individual in the car was stopped because they had a taillight out. The officer pulls over the car for having the taillight out, finds drugs in the car. The North Carolina Court of Appeals construes the statute as requiring a stop lamp. That is, you only need one operating taillight. This was a traffic law that was drafted a long time ago. And so the court says, well, there was no violation. Actually, it's totally lawful in North Carolina to drive with one taillight out.
News you can use.
News you can use. And the question in the case is whether you can have reasonable suspicion to stop someone under the Fourth Amendment based on a mistake of law. That is a reasonable mistake that you'd think that that's unlawful, but actually it's not unlawful, or whether you have to sort of hold the government to the law as it is actually construed by the courts, even if that construction happens later and it's a kind of counterintuitive construction. So that's really a question under the Fourth Amendment about how you interpret reasonable suspicion, probable cause, and if there's a counterintuitive reading of the law that happens later, do you hold the officers to that interpretation or not? So that's a very quick run through of the three cases.
You are the rare panelist who actually is told to spend 5 minutes and spends maybe even fewer than 5 minutes. Let me ask you a question about this last case. And in general, you've avoided giving a kind of take on the right answer or a prediction about what the court might do. I wouldn't mind each in all three cases. But let me ask you this on the taillight case. Am I right in thinking that there would be a gap, Warren, between the criminal defendant, who, as I understand it from all the cop shows that I've seen, can't say, I didn't know that was the law, therefore I get off, and the cop saying, I didn't know the law, but yet I can search your car?
Yeah, I mean, I think my own view is that the defense should win in the Hine case because the maximum ignorance of the law is no excuse should apply as much to officers as it should to individuals. And also, I think it's very easy for the government, especially in the traffic context, it's sort of hard to drive without violating a traffic law, right? And that can include, 1 mile an hour over the speed limit. So it's not like the executive branch of a state or federal government lacks the power to go to the legislature and say, okay, we should have a law that makes it should be unlawful to drive with one broken taillight. So this is something that's very easily fixed by the legislature. And ultimately, if the court was right in its construction of the statute, which I think you have to assume they were, the individual who was driving was doing absolutely nothing wrong and shouldn't be pulled over for it.
And what do you suppose the court will do?
It's hard to know. What makes the case a little bit tricky is that you could interpret this case in two ways. The case is not handling the remedies aspect of this case. So you could say that it's an unlawful violation of the law, but there's no exclusionary rule, and you get to the same result as you would if you said it's lawful. I suspect that if the court had the exclusionary rule aspect of this too, they'd say the exclusionary rule doesn't apply, and so they may just kind of say, well, it doesn't make, it may be a case that ultimately makes no difference. It's sort of conceptually interesting, but may not have a whole lot of ramification.
Let's turn to Will Consovoy.
Thank you. I have two cases to cover briefly here today. The first one is Holt versus Hobbs. In one sense, it comes off as a very straightforward question of federal law under the Religious Land Use and Institutionalized Persons Act of 2000. This statute grants religious freedom to people incarcerated in state prisons when the state prisons accept federal funds. Arkansas does accept federal funds, and they restricted an inmate who, for religious reasons, wanted to grow a half-inch beard to only growing a quarter-inch beard. The question directly presented here is, was that the least restrictive means available to advance what the institution claimed was a compelling government interest? There was an extensive hearing in the district court. The prison won, largely based on principles of deference to prison administrators. Before last term, you might have thought that is likely how the case was to come out. I think what's happened in the interim was Hobby Lobby. And I think a lot of people rightly are seeing this as a direct follow-on. There was a different federal statute, RFRA, but they're seen as companion statutes. They're interpreted the same. And I think the harder question now is, given what the court did in that case, why does not the inmate have broader religious freedom here? And what you're going to see in this case is a real tension between the court's historic deference to prison administrators on how to run a prison. There is a lot of evidence in the state's brief which demonstrates and illustrates some of the things that can be hidden in a beard. Weapons, contraband, more than you might think in a half-inch beard. At the same time, there were lots of alternatives offered up as to ways to accommodate the interest and also meet the safety needs, which the Eighth Circuit all rejected. And so I think here you're dealing with a situation of the inmate having a very strong case in terms of the right to religious freedom and the right to practice it as he sees fit. The second case, or really two companion cases, involving Alabama redistricting. One brought by the Alabama Democratic Conference and another brought by the Alabama Legislative Black Caucus. This is about as complicated a redistricting case as you're going to find. I'm going to try to quickly walk through the various issues that are going on here. Essentially what happened was, after 2010, Alabama faced a problem, and the problem was they had majority-minority districts that were underpopulated. And so when you cut through all of the legal jargon, what you get down to is a fundamental question of, you have to move people into those districts. Are you going to move minority citizens into those districts, or are you going to move white citizens into those districts? And Alabama was facing 4 different legal regimes that they had to navigate in order to decide that question. One, they had to meet one person, one vote, which means you have to have about roughly equal population in every district. Second, they had to deal with Section 5 of the Voting Rights Act, which says you cannot retrogress minority voting power. So if they moved, there was an argument, which they believed, that if they moved white people into those districts, that would reduce the minority voting strength in those districts. However, if they moved minority citizens into those districts, they ran into an equal protection problem, because they would be accused, and were, and have been in this case, of packing minorities into districts to create safe minority districts, but then undermine their broader representational rights in other districts, and that would violate the 14th Amendment. And finally, they had to deal with Section 2 of the Voting Rights Act, which creates arguments both along equal protection and Section 5 grounds. So what Alabama did was focus on one person, one vote, in their argument, to the exclusion of the other issues. They won 2-1 before the special 3-judge panel. The dissenting judge said they did not have strong enough arguments, that they were packing, and that is the ground on which the court has accepted review.
So I welcome comments also from the other panelists, but let me ask you a question about each of these cases. Will, do you think it makes a difference in the prisoner case, who wants to grow the half-inch beard, that 44 states and the federal government seem to think there's no security problem there? I do think it makes a difference. And I think it will bear on the outcome of the case. I think we're seeing increasingly in a variety of criminal cases, particularly in the Eighth Amendment area we've seen, where the court does care about the views of the other states
on issues of prison security and inmate rights, yes.
And on the voting rights case, without getting too much into the weeds, you all recall that in 2013, the court effectively struck down a key feature of the Voting Rights Act, Section 5, which required states with a history of discrimination to obtain so-called pre-clearance, to get the permission of the federal government, either the Justice Department or a court in Washington, before it could make changes to its voting procedures. And Section 5 was the reason offered by Alabama officials to do what the plaintiffs say was packing. Now that Section 5 has gone away, does that change the contours of the case?
You know, it's a really complicated issue. I think the answer is yes. And in disclosure, I was one of the lawyers on the legal team for Shelby County. And it's a very strange place, because you have it being a central issue in the case when it was decided in the district court. And now if the court were to find, if they do what the Solicitor General's office has asked, which is vacate the decision below and send it back for a better analysis, you're going to be vacating a case on a ground that no longer may have any pertinence to the case now that it's on remand. I think it's a very strange, and I think the real question is, how much capital is the court going to want to invest in interpreting the substantive standard of a statute that no longer applies? And it's been in the briefing, so I think they're going to have to.
All right, Virginia?
So I, too, have been tasked to talk about two cases, and first I'm going to talk about Zivatovsky versus Kerry. And that's a case that involves a conflict between the president and the Congress in the very controversial and difficult setting of, Middle East domestic and international politics. The Foreign Relations Authorization Act directs the Secretary of State on request to record the birth country of an American citizen born in Jerusalem as Israel on that person's U.S. passport. President Bush signed that law, but said that this requirement's not consistent with the president's constitutional authority to conduct foreign affairs, and more specifically with the president's recognition power if it in fact requires this denomination. The State Department has, since the passage of this statute in 2002, refused to enforce the law on the ground that it's incompatible with the government's established neutrality on the status of Jerusalem as part of either Palestine or Israel. Instead, it lists the birthplace of U.S. citizens born in Jerusalem as just Jerusalem. Now, the Zivatovskys were U.S. parents living in Jerusalem when their baby was born, and this case arises from the State Department's denial of their request that his passport indicate that he was born in Israel. Again, their child was born in 2002, so that just demonstrates that this statute's been controversial since the beginning, and in fact, this is only one in a sort of procession of statutory provisions that create conflict between the executive branch and Congress, Congress pushing the U.S. policy towards the recognition of Israeli sovereignty over Jerusalem. So the Supreme Court's seen this case before. A couple of years ago, the D.C. Circuit had held that it was the conflict about whether the statute had to be observed or whether the State Department could rightly resist was a political question. That issue went up to the Supreme Court, and the Supreme Court said, nope, it's not a political question. And so now they're going to reap what they've sowed, which is they're going to have to decide the question about whether the president indeed has exclusive recognition authority or whether what Congress has done is within its control over passports and over the regulation of immigration, and so and isn't really a significant infringement on recognition, doesn't amount to an official act of recognition. And so I think the court is going to find itself in a very difficult question, having to resolve this power question between the executive branch and Congress. The D.C. Circuit below held that the president's authority was exclusive and plenary, and in fact that this requirement that Congress imposed would infringe on recognition power. In part, I think the statute itself creates the problem here. The statute itself says that it is the policy of the United States that Jerusalem is the capital of Israel. And so this is one of the things that creates the significant infringement upon the president's recognition authority, rather than opening up somebody's passport and seeing the word Israel instead of the word Jerusalem. But it doesn't change the sort of practical reality of the situation from the point of view of the State Department, which I think is that if the Supreme Court were to reverse and say that the statute has to be enforced, there would be a perception, at least the State Department believes there would in the Middle East, that the United States had retreated from its long-established policy about neutrality on the status of Jerusalem. And so, there's sort of a practical problem of perception presented to the Supreme Court in this case, as well as the sort of difficult constitutional interpretive question about whether the president's recognition authority is exclusive, as has been thought since the time of George Washington, and whether this particular statute is an infringement on that exclusive recognition authority. It's an extremely difficult and important case that creates both theoretical, I think, and practical difficulties for the court. From that, I'm going to discuss my second case is in a much more normal area, which is labor and employment law. The courts at this point granted 5 labor and employment cases. 4 of them involved traditional issues of statutory interpretation, a question of whether certain time is compensable under the FLSA, a question of interpretation of Title VII, a very important case under the Pregnancy Discrimination Act about exactly how that prohibition on pregnancy discrimination should be interpreted. But I am not going to talk about any of those cases. I'm going to talk about the one labor case that was granted, which is a case called Tackett. And it seems notable to me because for 10 years, people have been petitioning the court to grant this issue, and it is very difficult to see why now, after 10 years of conflict among the 6th, 3rd, and 7th Circuit about this issue, they would all of a sudden grant now. So the question is, way back, unions routinely negotiate for health care benefits for retirees of the union as well as for active employees. Been going on for decades. I used to represent the steelworkers. All the steelworker contracts include negotiated provision for health care for retirees. A couple of decades ago, as health care costs started to accelerate substantially, employers were, operating under increasing burdens of healthcare costs and started to think about things like using HMOs instead of other kinds of plans, thinking about cost contributions, co-pays, and as they would change the plans that apply to retirees, retirees would sue and it'd say, look, my healthcare benefits were vested. I acquired a vested right to lifetime benefits once I retired under this collective bargaining agreement. The 6th Circuit, in a very important case called Yardman, said, yes, when you think about what retirees must have presumed at the point at which they retired, almost any language in a collective bargaining agreement that talks about duration should be interpreted with a thumb on the scale towards belief that retirees have lifetime vested benefits. Fast forward a couple of years, healthcare costs continue to accelerate, and the 3rd Circuit gets a hold of the issues, and it says no. If there's not a clear statement that the benefits endure beyond the duration of the collective bargaining agreement, then the benefits are not vested for life. The 7th Circuit ended up coming down somewhere in the middle, saying we need some language that's indicative of continuation to find vesting of lifetime benefits, but we don't require a clear statement the way the 3rd Circuit does. As I said, I think there have been at least 12 cert petitions since that conflict stabilized, raising this issue with the court. And I've been racking my brain thinking about why it would be granted this year above all others. And I think some of the explanation is in the sort of increased public attention to the availability of health care and to possible increased public interest in what kinds of, where and how you obtain a legal right to certain kinds of health care coverage. But that's pure speculation on my part. It's been a long established conflict in a very important area to employees who retire with, I think, reliance on the fact that they have health care coverage for life, and for employers who face increasing health care costs that they simply don't know how to manage as they negotiate new contracts with their unions. Very important case, I think, even though it's not on the, it's not a case that's going to get the most public notice this term.
Let me take you back for a second to the Zivatovsky case, the passport case. I'm scratching my head, and I see a reference to the president's power or maybe duty or maybe obligation to receive ambassadors. But where else in the text of the Constitution is this recognition power you speak of?
I think the source of the recognition power is in the president's authority as what the court has long held is the sole instrument of U.S. Diplomacy or U.S. international relations. That, in combination with the receipt of ambassadors provision and the fact that since the time of George Washington, presidents have acted unilaterally and connection with recognition is what I believe the government will rely on to say it's plenary and exclusive authority.
Adam?
Thanks. I'm going to talk about two cases that discuss the relationship between Congress, the courts, and the administrative state. These are both cases that the Supreme Court has agreed to hear, and furthermore, they're both cases in which my firm is filing amicus briefs, in both cases on the side challenging the government's action. The first case has to do with Amtrak. It's called Department of Transportation against Association of American Railroads. The basic issue is this. In 2008, Congress and the President passed a law instructing Amtrak, jointly with the Federal Railroad Administration, to promulgate new regulations regarding the standards for performance of trains on these tracks. The catch is that Amtrak is basically a competitor with the other trains that are going to be regulated by these rules. Amtrak has passengers. The other trains are mostly freight, but they are competing for scarce time on the tracks. And so, needless to say, the freight rails were none too happy about suddenly being regulated by one of their competitors. After Amtrak and the FRA promulgated the regulations, the freight rails sued in district court, saying that this statute violates the non-delegation doctrine. Now, for con law or administrative law people out there, when you hear non-delegation doctrine, you might think of the so-called intelligible principle, that Congress has to specify an intelligible principle for agencies to administer. This is a slight variation on that. Back in 1936, the court decided a case called Carter-Cole that set a per se rule that Congress can't delegate rulemaking power to private entities. And the challengers in this case say this is a direct application of that case. Amtrak is private, and therefore it can't exercise rulemaking power. Well, that's pretty straightforward if Amtrak's private, but that leads us to the second issue in the case, namely, is Amtrak private or is it government? A good friend of mine, when he heard about this case, he said to me, Adam, if you have any doubt that Amtrak is government, just try the food. That's a fair point, but it's a little bit more nuanced than that. There's a statute out there that says Amtrak is not a department or agency or instrumentality of the federal government. Rather, it's to be operated as a for-profit corporation. And so there's going to be a big fight in the case over whether Amtrak is public or private. The second case I'm going to discuss is called Perez versus Mortgage Bankers. It has nothing to do with the non-delegation doctrine. This is a case about in what circumstances does an agency have to go through notice and comment rulemaking before it changes its interpretation of its regulations. We all know how a bill becomes law. We all know how when you promulgate regulations, for the most part, you go through notice and comment rulemaking. But what happens when an agency changes its interpretation of a rulemaking? In this case, the Labor Department had in the past interpreted regulations regarding overtime pay for administrative employees. The question was, are mortgage loan officers, are they administrative employees who are exempt from the overtime rules? Originally, or not originally, I don't think that's right, but in the past, in 2006, the Labor Department said, yes, they are exempt from the overtime rules. In 2010, the Labor Department reversed that interpretation of its regulations, said, no, they are entitled to overtime pay. And so the Mortgage Bankers Association challenged the rules, saying that because the Labor Department made a significant change to its definitive or authoritative interpretation of its rules, it needed to go through notice and comment rulemaking before making that change. But here's the catch. Under the Administrative Procedure Act, which basically sets the standards for administrative procedure, there's a black letter rule that interpretive rules and policy statements and guidance are exempt from the notice and comment requirement. But in the DC Circuit, there's a couple of old precedents, Alaska Hunters and Paralyzed Veterans, which say that when an agency makes a so-called significant change to a past authoritative or definitive interpretation, they do have to go through notice and comment rulemaking because it's more than interpretation. They are, in effect, changing the rule. Now, that DC Circuit decision sparked no small outcry among administrative law professors. 70 of them, I think, filed an amicus brief urging the court to hear the case, saying that the DC Circuit's standard is just completely wrong and at odds with the Administrative Procedure Act. They compared it to this seminal administrative law case called Vermont Yankee, in which the Supreme Court said that the courts of appeals can't add on to the standards already set forth in the Administrative Procedure Act. So it's an interesting case. Cases like this, they might seem like they're very narrow issues, But in the last few years, there has been this interesting series of cases in the Supreme Court about the relationship between the courts and Congress and the agencies. A few years ago, Justice Scalia started to question the amount of deference that the court should give agencies in interpreting their own regulations. Recently, there was a case called City of Arlington about do the courts defer to the agency's interpretation of the agency's own jurisdiction. Last year, there was a case called Utility Air Regulatory Group about the extent to which it was a statutory interpretation case, and at the heart of it was the EPA's effort to substantially interpret, some would say rewrite, the straightforward numerical standards of the Clean Air Act. And I think the Halbig case, the Healthcare Exchanges Act case, is in a similar vein, and Kerry will talk about that. But it's very interesting to watch the courts sort of at the margins and little by little sort of test the boundaries of deference of the separation of powers, and it manifests itself in interesting cases.
So, Adam, what's the theme that runs through those cases, and does it tend to divide the court ideologically?
Well, let me start with the second question. In terms of the divide, it actually cuts across the justices. Administrative law cases cut across the justices in interesting ways. We see this especially with Justice Scalia, who on the one hand, a lot of conservatives cheered him on when he started to question deference to agency interpretation of rules. But then in the City of Arlington case, he writes the court's opinion saying that the court will continue to defer to agency interpretation of the agency's own jurisdiction. And so the justices line up. Justice Breyer, Justice Thomas, they often say very interesting things in this case, and Chief Justice Roberts as well. In terms of the theme, maybe I'm overthinking this. Maybe the justices take these cases one at a time, and they really stand on their own merits, and there isn't a connection. But for me, I do think there is this sort of broader, not broader rethinking, but this much more thoughtful reconsideration of the relationship between the courts and the agencies in terms of deference, and in terms of Congress, the president, and agencies in terms of separation of powers.
So we've given you a nice overview about the cases on the docket already. You can judge for yourselves how big they are. I would suggest that at the end of June, they're not going to be on the front page of my newspaper. But a couple that Kerry, looking forward, is going to discuss might well be.
Right. So I have a challenging job, which is to look at what's coming up. And as the court is sitting on Monday for what it's known as the long conference, where it considers a huge number of cert grants, many of the cases I'm talking will be considered then. So much of what I'm saying could be moot within a week, or I'll look incredibly prescient. So we'll see what happens. And at any rate, I think at the bottom, all of the issues I'm discussing, even if they aren't considered by the court this term, are something that the court will decide at the end of the day, if not this term, probably next term. So if it turns out they don't take any of these cases, you guys can just invite me back, and I'll give exactly the same talk next year. Simplify things for everyone. So the first cases Adam alluded to that I want to talk to are the Halbig and King cases. These are really the next big challenge to the Obamacare regime. This one actually is interesting because the challenge is actually trying to get the text of the Affordable Care Act enforced literally according to how it was done. So it's not trying to overturn the Affordable Care Act, it's actually trying to enforce it as against an IRS regulation. In the Act, there's a provision that the subsidies provided for are available for plans purchased on, and the quote is, an exchange established by the state under Section 1311 of the Act. So the IRS, in the face of a kind of unexpected 34 states that did not establish exchanges under the Act, wanted to make sure these subsidies were in fact available nationwide and not really in a minority of the states. So they interpreted it, so going back to our question of agencies interpreting the statutes and what the leeway they have in doing that is, they interpreted it in a way that has been charitably called somewhat a mismatch with the text of the statute. They said an exchange established by the state shall also include exchanges established by the federal government. Because in cases where the states didn't establish an exchange, it's the federal government that then did so in its stead. And what we have in these cases is, in the King case, we have a group of individuals, and in the Halbig case, a group of individuals and employers who sued, arguing that this was in violation of the law, that the agency may have the right to interpret the statute, but they don't have the right to rewrite the statute. That's for Congress to do. And in this case, it's the implications are not only that the people in those states would not get the subsidies, but also that millions of people in the states will also not be subject to the individual and employer mandates as a result of the subsidies being unavailable. So the numbers I've seen are about 5 million people would, if the IRS is incorrect, if the text sort of reads as the plain text meaning, about 5 million people would therefore not get subsidies, but another 8.3 million would not be subject to the individual mandate, and 57 million would not be subject to the employer mandate. So there's huge implications for a lot of people. Obviously, it's a majority of the states that are involved. What we saw in these two cases was basically the fastest circuit split probably in American history. On the morning of July 22nd, the D.C. Circuit held in Halbig versus Burwell that this was an improper interpretation by the IRS. And then by early afternoon, the Fourth Circuit had held in King versus Burwell that, in fact, it was fine, that this was okay, and the IRS has the authority to do this. So normally, a number one thing that the Supreme Court's looking for in terms of granting a case is a circuit split. So they had one right there. The King plaintiffs who had lost wasted no time in filing their amicus or their petition for cert. Instead of the normal 90 days, they turned it around in 9 days. And then it could have almost been practically been considered by this first conference, but because the government was given a 30-day extension, it probably will be considered maybe in October, possibly very early November by the court. In the meantime, the government asked the D.C. Circuit to take this case, the Halbig case, on Bonk, so there's a possibility that the court will then, which now is composed of a 7-4 majority of Democratic appointees, that if they vote, as many have predicted, kind of along party lines, then they will overturn the decision of the panel and will erase this circuit split. So the question is whether the court will even take this case, given the fact that the split is in question. I think there's a lot of arguments as to why they would. The court does consider cases that are major questions when there is not a circuit split. I think there's also a good argument that even if there isn't a circuit split at the time the case is argued, there's a good chance there will be a circuit split at some point down the road. These 30-some states are in 10 different circuits. Until all of those circuits have decided the issue, it's still going to be a question. This is causing huge uncertainty for everyone in the state who wants to buy insurance, all of the employers in the state who aren't sure whether they need to offer it, whether they may need to, as unfortunately a lot of employers feel forced to do, cut hours of their employees to make it possible for them to continue not offering health care, or have to fire people to make it impossible for them to afford to pay for the health care, and for the states themselves to know how to be regulating. So it's a major issue, and we'll see it. This is another case that could fit into the pushing back on Chevron deference theme, because there's questions, does Chevron even apply here? Because the IRS is implementing a health care law. Of course, it may be a tax. It may not be a tax, so whether you feel like it's a tax or not might fit into that question. Whether the statute is in fact ambiguous, and whether that interpretation is reasonable. So there's that, and I think this also fits really well into the theme of the growth of federal government, the growth of the administrative state, and the pushback of the courts on some of these constitutional limits on government, and particularly on the constitutional and the issues we've had with this president. I think having a less respect for the separation of powers and the limits on his own authority by the Constitution. As long as he's got his phone and his pen, he seems to take a less serious view of his constitutional obligations than maybe some people would feel he should. And I think the court has definitely pushed back on that historically in the last couple terms. We've seen the Solicitor General's office has had a pretty dismal success rate, and I think that some of the aggressive positions of the administration may play into that. The second set of cases is the marriage cases, and this is even harder because there's a slew of circuits that have petitions already on Monday's conference. The Fourth Circuit, the Seventh Circuit, and the 10th Circuit all have multiple cases that have petitions out there. There's also decisions that could come down at any point in the Sixth Circuit, in the Fifth Circuit, and in the Ninth Circuit. One challenge is, as in the Halbig and King cases, there's not actually a split right now. I mean, in those cases, there's a split, but it may go away. In these cases, there's not a split yet. All the circuits that have considered the issue have looked at it the same way. They have all overturned various state laws and constitutional amendments that limit marriage to a man and a woman, and the laws that have defined it that way, going back to statehood in many cases. How the court will take the cases is hard to predict. We had Justice Ginsburg just a week or so ago commenting at the University of Minnesota Law School that we have to kind of wait for the Sixth Circuit to find out what they do to figure out whether there's going to be a split. So she seemed to be suggesting, why rush into these cases? There's no split yet. We'll wait till one occurs. I think it's reasonable to think there may be one. The Sixth Circuit oral arguments, in which case they considered 4 different state laws, Michigan, Ohio, Kentucky, and Tennessee, seemed to lean in favor of upholding those laws, and that would create the first split in this issue. There's also the Fifth Circuit, which is seen as one, depending on the panel, that has a decent chance of upholding the state laws, and that has a case that has not yet been scheduled for oral argument out of Texas, and recently had one in Louisiana that was one of the rare district court cases that also upheld the state law. So which case might be considered? I think there's a lot of very complicating vehicle issues, as we would always call it as clerks, in terms of problems in the various cases. Some of them, like, for example, the Fourth Circuit case with Virginia, they have a question because the Attorney General isn't actively supporting the law, and so you come up with questions much like the ones that the Supreme Court faced in the California Prop 8 case. How do you do when you have the state executives refusing to defend the law? That creates problems. Who can defend it, and whether they're allowed to petition or appeal when they've in fact lost a case that they wanted to lose. I think both the Seventh Circuit case and the Tenth Circuit case out of Utah have solved many of those questions. We have states that have governors and attorney generals and county clerks who are all interested in supporting their laws. We have an interesting combination. I think in both of those cases you have both a question of licensing marriage licenses within the state as well as recognition from out of the state, whether you have to recognize marriages contracted in other states. And in the Seventh Circuit, I think they have both due process and equal protection clause challenges. So that might be a chance for the Supreme Court to get all of the issues on the table in one fell swoop. All of these cases are, in fact, beating the rate pace of petitioning for cert that we saw in the King and Halbig cases. I think, were for not only in the Seventh Circuit, for example, not only did Judge Posner turn around his decision a mere 9 days after oral argument, but I believe it was only 2 days after the decision came down that they all filed it's 5 days after the decision that they all filed for cert, and in fact the response was in the same day that the petition was in. So everyone seems to want to hear these cases. In all of them, I believe, the states have responded saying, we won, but please take our case anyway. I think this is a rush to who gets to be the case that decides this, whose name is going to be on it, and who's going to get to argue it before the Supreme Court. And I think that could also affect how the court views it as well, because everyone's making slightly different arguments, although generally all on the same lines. So in terms of some of the issues, I think will be similar in either this case or the Affordable Care Act cases, because the split is in question. It's an important issue, and it's certainly affecting a large number of people. Maybe not the 57 million that are in the that are affected by the health care mandates, but there are certainly many people who want to see this solved, and if it's not solved this term, I'm sure the court will have to deal with the case eventually.
Thank you for that, Kerry, and I think some of the themes you've touched on are so interesting. I'm going to ask the other panelists to chime in a little bit, but let's take them one at a time. Let's talk about the Halbig and King cases. I don't think you said directly, but it's the undercurrent, isn't it, that if the challenge succeeds, it's very hard for the law to be sustained, right? The law falls apart.
I think, yeah, it's how fast it does so is going to be a question, but having the subsidies unavailable in those states will be a severe blow to the law. So not as severe as like the original Commerce Clause challenged the case, but it definitely would fall under its own weight, I think.
And if there is that fear, how likely is it, understanding that the plain text, is very supportive of the view that you laid out, how likely is it that Congress wanted to put such a time bomb in section, 1311 sub B sub 4 in one phrase?
Well, I think actually there's contemporaneous evidence that they did know what it was. I mean, Jonathan Gruber, who was one of the architects of the laws, has commented on this. They didn't think of it as a time bomb because I don't think they thought the states would really go through with not establishing these exchanges. I think they thought of it as forcing the states to play ball and be part of and get their exchanges going because they wouldn't want to lose the subsidies. But at the end of the day, what Congress intended is, first of all, unknowable. You've got hundreds of individuals to look at. And I think for the same reason, isn't actually what the court should be looking at. I think we need to hold Congress's feet to the fire, and their job is to write a law, and we're going to interpret the law, and not have the IRS going back and trying to cover their backs, and not have the Supreme Court going back and trying to rewrite the law for them. If we're to maintain accountability of a system, we need the Congress knowing that its words actually make sense, and we don't just throw something on paper and pass it and read it afterwards. You really do need to do your homework up front.
So sticking with the ACA case for a second, I'd be eager for anybody's thoughts on either that substantive point Kerry just made or the point that at least the reporters in the room are very interested in. Is the court, now that the circuit split has gone away, nonetheless likely to grant cert on this important question this term from the Fourth Circuit case? So any thoughts on either of those points? You're a hell of a group.
No one wants to actually make a prediction because we know it's going to 50-50 are going to be wrong.
Let me say something to this. I mean, I wrote an op-ed when the rehearing petition was pending, walking through the D.C. Circuit's history of rehearing and not rehearing cases, and it seemed to me that the place of the D.C. Circuit had been over the last 20 years indicated that it would pause before rehearing the case. Obviously, I got that one wrong, so caveat emptor. But while the debate was going on about whether the D.C. Circuit should rehear the case, we kept hearing, oh, this is extraordinarily important. This case is so extraordinarily important. The D.C. Circuit needs to rehear it. It's such an important case. It's a little strange to hear the administration's supporters say that over and over again, and then say to the Supreme Court, oh, well, it's not that important. You know, it's important enough that the D.C. Circuit needs to rehear this immediately, but it's not the sort of thing that we need the Supreme Court justices to weigh in at this point. Having seen the ferocity surrounding the debate over rehearing, you have to wonder what the justices were seeing and watching, because they don't live in a vacuum. I mean, they see all this happening around them, and you have to wonder whether the cacophony that surrounded the rehearing request might influence the court's eagerness to just take this case up. I mean, after all, it is extremely important, they said.
Adam, I'll bite if I had to guess, I would guess the court won't take the case absent a split, in part because I think in their minds they think, all right, they're done with the Affordable Care Act, right? It was the case of the term not long ago, and it was, from what we can tell from the leaks of the case, traumatic and really a big, difficult case internally, and I suspect they wouldn't be eager to jump back into this unless there's a split, which would be kind of the traditional criteria for jumping in. So I suspect they'll wait.
So let me ask you a counter scenario, which is a couple of years ago when they decided the last case, there were 4 justices who were pretty unhappy and pretty eager to take down this law, and it only takes 4 votes to grant cert. And those justices might be eager to jam up the Chief Justice, or at least that's one way of thinking about the court, but that's probably too cynical.
Even if that cynical view is right, which I'm not saying it is, if that view were correct, I think that would, if the case is seen as kind of a way of getting back at the Chief Justice or forcing them to take it on again, then presumably they fall on the same along the lines that they did the last time. So I think, especially if you favor the challenge, it looks a lot more credible coming from a split than it does if there's no split.
Just one more thing on that. In addition to the 4 justices in the individual mandate case, not to drag this kicking and screaming back to administrative law, but there were 5 justices last year who voted against the EPA's sort of their frontline arguments in the Clean Air Act case. They said, no, under the greenhouse gas statute, or the Clean Air Act applied to greenhouse gases, words and statutes mean something. You can't just claim that the results of a contrary interpretation are absurd, and then substantially rewrite the statute in order to maintain the program. It seems to me that there are very strong echoes of that EPA case in the healthcare exchanges case. And there are 5 justices there. And I mean, I think, was it the other EPA case last term, the cross-state air pollution rule, where Justice Ginsburg maybe said that the job of the court isn't to promote the policy that they think would be best, but rather to apply the statute as it's written. I mean, that works in this case as well.
So that may well tell you something about where they come out on the merits, should they take it, but less about whether and when they will take it. Other thoughts on the ACA cases? So let me move to the marriage cases, which are really very likely to be the centerpiece of this term, and turn it into whatever else they take, whatever fish shredding cases they've taken, whatever Facebook rap lying cases they've taken. If they take same-sex marriage, as they're likely to do in the coming weeks, that's going to mark this term. That's going to be a huge case. But let me not get ahead of myself. As Kerry pointed out, there is also no circuit split here. What's our thinking about whether this is the kind of case where the court cares about a circuit split, bearing in mind that it's no small thing for federal judges around the country, and repeatedly, to be striking down state laws and provisions of state constitutions? Is that enough, or should they wait for a circuit split? I'm going to start calling on people by name if you don't talk about it.
I'll start. I mean, it's a very unique posture, I think, for the reason Kerry said, which is they're not getting any briefs from any parties telling them not to take the case. Mm-hmm. And I think that's what puts the court in an awfully difficult situation here. I do think there's and when you saw how the California case came out last time and the voting alignment in that case, and then you see the comments that Justice Ginsburg is making, I do think there's a hesitancy here that cuts across, party lines or jurisprudential lines, but at the same time, they're almost being backed into a corner, and I think the sort of undercurrent which may drive some of the decision-making is having to deal with all these stay requests, which are very complicated, which are causing, real difficulties in terms of the lower courts. I think there was one judge, and I believe it was you, Ty, I may have this wrong, who said, district court got very upset and said, I understand the court has been granting stays in other cases. They're not issuing opinions explaining why they're granting these stays. I am not going to grant one. And so I think there's an institutional capital here in terms of how many stay requests is the court going to deal with until they take the case on the merits.
And I think the importance of this case is so great that, they take cases of much less weight just on importance grounds. And so, I think they will take this case, one of these cases.
I think one other factor that got talked about a lot when the marriage cases were up a couple of years ago that hasn't been brought up as much, but even Justice Ginsburg kept on talking about the aftermath of Roe v. Wade and the way that the court took that case in her description, instead of taking a step-by-step view, went broad on that case, and as a result has spurred 40 years of pushback. You still have people marching on the Capitol every year. Is totally transformed the way we look at judicial nominations. It's a litmus test. Do we want marriage to be the next Roe v. Wade? I think that in some ways it may be that the court isn't going to be able to avoid looking at the issue, but I think that's something the court is concerned about, and maybe this is part of the reason that she was suggesting maybe we want to wait as long as we can before getting involved in this case. The challenge, as Will pointed out, is that we do have almost a fever of lower courts that are just rushing as fast as they can to overturn every state law they can find, and so whether the Supreme Court gets involved or not, you certainly have courts who have gotten involved, and so whether you still have the case of courts overriding democratically elected positions and laws. So it may be impossible for the court to avoid the specter of a repeat on such a controversial issue.
But what wonders is what Justice Kennedy is thinking as all this plays out, right? I mean, so often these Supreme Court preview panels, they seem more like Justice Kennedy preview panel with special guests, 8 other justices. But, I mean, on the marriage cases, it's especially so, right? I mean, the precedent that everybody's looking to is the Windsor case, the Federal Defense of Marriage Act case that Justice Kennedy wrote. And he wrote about liberty, and he also wrote about state authority and federalism. And it wasn't clear to anybody really at the time where he was going with this. And so what we've seen in the aftermath is a lot of federal courts focused on their version of liberty. with really much less care for state power and federalism. Maybe Justice Kennedy is happy to watch this all play out. On the other hand, maybe he's looking for another opportunity to clarify what he previously wrote.
So it is the case, though, isn't it, that Justice Kennedy is the author of all 3 major gay rights decisions. It is likely to be his legacy, and it would be a little bit surprising if he would take a turn now when the polling numbers and the courts and so much of the nation is moving in one direction. Or do you disagree?
I'm not going to make any money betting on what Justice Kennedy is going to do in a given term, but Justice Kennedy has written a lot in his career about federalism. He's written a lot in his career about individual liberty. Oftentimes it seems that for him, federalism is a means to the end of liberty. It's not quite clear how it's going to play out, and I think this dispute, more than anything else he's dabbled in, takes these 2 lines of Justice Kennedy's thought and pits one against the other. I think it's going to be fascinating.
Actually, to the poll numbers, I think there was a recent Pew poll showing that support for same-sex marriage has dropped from the last one. Whether that's a blip, I don't know. But you also can wonder if that is a little bit of that same effect I talked about when you have people who feel like the courts are jumping in and usurping territory that really should be worked out in the political and in the social spheres. Maybe him making the decision almost would undermine this being viewed as a positive legacy, or would at least create, a deeper trench in the conflict. So I don't know. I don't know if Justice Kennedy wants to make that decision. If he wanted to make it, he probably would have done it last time. So, well, I don't know. We'll see.
Right, well, you're quite right that
I don't think he wants to decide. I don't know if he wants to decide it on either side or the other. He'd probably rather step back right now.
When the core issue came before the court last year, not the Doma case, not Windsor, but in Berry, it was plain as day that Justice Kennedy didn't want the case to be before him, had not granted for cert, and was delighted to see it go away. But I don't think anyone predicted that Windsor would be received as it has been, with everyone focusing on one of the 2 theories in the case, the liberty theory. And whether the court wants to or not, it does seem, and I think this is probably something like a consensus, that it's going to be hard for them to avoid getting into it, whatever the result. That's right. So let me ask one more general question, then I'll turn to your questions. At the end of the last term, it was hard to write that newspaper term wrap-up story, partly because reporters like conflict, and there was substantial conflict at the very end of the term in Hobby Lobby and Harris against Quinn. But it was also a term that had an extraordinary amount of unanimity. The largest in the modern era. About 2/3 of the cases were decided unanimously, not all of them unanimous on the rationale, but many of them. And I'm wondering whether there are thoughts here about whether that's a blip, or whether that's testimony to the court trying to get together, whether it's testimony to the Chief Justice playing a role in getting the court together, or whether it's the nature of the docket on some of these statutory cases we've been talking about, which may be areas in which the justices are less apt to disagree.
Adam, I'll take the guess that it's a blip. Because first, I think we've only seen the trend over one term, and there's sort of nothing specific about the term that would have suggested an overall broader shift. The personnel at the court are going to change within a year or 2, probably, or at least 4 or 5 years. And so my guess is that it's just a 1-term event, maybe 2-term event, but not something that's, we're not going to enter a new period of unanimity at the Supreme Court.
I tend to agree with one minor caveat, which is I do think the Chief Justice's approach to constitutional avoidance in major cases has led to more unanimity than you might have otherwise seen. And Justice Kennedy has been with him on most of those, and most of the court has come with him. So you look at Bond, you look at Northwest Austin, and other cases of that kind where the court was on the brink of making a major constitutional ruling, step back, and everyone coalesced around a statutory question. When you see cases like that come up, I do think that is part of what's going on here.
And I think there's an agreement, a broad agreement on a method of statutory interpretation that will cause at least some convergence in some of the major interpretation cases that don't press people's buttons too much. For example, the Fair Labor Standards Act case I would predict there'd be some unanimity on the statutory interpretation question. So I think in cases that are not directly in the limelight, there's agreement now, broad agreement on a method of looking at statutes, and you might see more agreement in those areas than in the hot button cases that have more interpretive play in the joints.
And it ebbs and flows, right? I mean, other panelists would know these cases better than me, but in cases involving the Voting Rights Act, and I think maybe campaign or affirmative action or campaign finance, the court was able, Chief Justice Roberts was able to achieve unanimity or near unanimity on a statutory interpretation approach, only to find the issue basically returned to the court a couple of years later, at which point the court fractures deeply over the ultimate constitutional role. And I think press accounts indicated that some of the justices were not too pleased with how things played out in the long run. I mean, the dynamic it changes over time.
Yeah, and I think I agree that some of the makeup of the cases also does factor in. You know, people have made a lot of the 13 unanimous losses by the administration, but when they take extreme positions, that aids the cause of unanimity, as do some of the cases they were considering. You know, the Ninth Circuit helps them with unanimity because they tend to be unanimously able to overturn them and stuff. So sometimes if you get a good rash of serious error, the court can look more unanimous than it is. Plus, I think there certainly were cases where there's absolutely ideological divide, but they managed to come together on a result, if not a reasoning. And that means that sometimes you'll get cases where that kind of unanimity can survive, but then once, as Adam kind of pointed out, once they are forced to look back at the case, it's going to break apart eventually.
So, Oren, you raised one thing that I should have thought to ask about: personnel changes. What's the outlook? And assuming there were to be a resignation in this administration, what kind of chances would the president have to appoint someone? Let me ask it this way. Justice Ginsburg, in suggesting that she's not going anywhere, has said words to the effect of, "Who are you going to get better than me?" And I don't think that was a statement of an egomaniac, but it was the statement perhaps of a political realist.
Yeah, I mean, certainly in terms of who's likely to step down next, everybody focuses on Justice Ginsburg. And in part, it's because there's no sign of anyone else, as far as I know, having any likelihood of that anytime soon. Of course, you never know what might happen. But in terms of what would happen if Justice Ginsburg did step down, obviously it depends in significant part on which party controls the Senate. I mean, that's going to be the big question, and we'll know more about that shortly. So that's a political process question, and it all depends on who votes for who.
Any other thoughts on that?
Yeah, I think it's 100% what happens with the Senate, because especially now that we've already seen the filibusters eliminated for other judicial nominees, and while technically they're still available for Supreme Court nominations, I think it would be very naive to think that Harry Reid would not get rid of those as well if there was any pushback at all on whoever the president nominated for the next one. So if the Democrats maintain control of the Senate, I think the president has a wide open field and could appoint another Ginsburg if he wanted to. I'm not sure he could get the 93 votes she did, but I think he could easily get 51. So, and I think that's all he'll need when Harry Reid takes the next, his next logical step there.
The Chief Justice just a day or two ago decried the partisanship around nominations and reminded us that Scalia was unanimously confirmed, and that Breyer and Ginsburg got just a handful of votes against. And now with the last 4 nominations, we seem to be in a very different climate. What accounts for that?
I don't think it's just the last 4 nominations. I mean, I think you can't talk about that without going back to Bork and beyond. So that's certain. The whole system has really changed from one of significant deference to the president to one in which there's a lot of pushback and a lot of fights on all of them. And honestly, from my perspective, I think that was clearly started by the Democrats making a huge deal out of Bork's nomination, out of Justice Thomas's nomination, and we're now, for better or for worse, in a world where that's how nominations are dealt with. I don't think we can step back from that now, because you're not going to get both parties to disarm simultaneously on such a sea change.
Although it was, post-Bork was Kennedy and Breyer and Ginsburg. So it didn't change every single nomination.
Sure, but I think now we're in a new world. I don't know that anyone thinks that we're still in that type of congenial thing. I'll let the other panelists see if they think there's hope for turning that back.
I don't think there's any downward ratchet in this process. I think it all can only get worse, and even when you think it can't get any worse, it does seem to. So.
Yeah. An interesting question, too, is what happens when you have the Senate in the opposite party control as the president. So at least up to now, the last few nominations, you've had the Senate in the same, controlled by the same party as the president. And so if everybody's voting on party lines, the nominee nonetheless will squeak by. Won't be pretty, but they'll squeak by. Things get much more complicated if the party on the other party is controlling the Senate, because then, of course, if everybody votes on party lines, they reject the nominee, the president comes back with another nominee, then you keep having party line rejections over time, and does the president then move towards a consent, more towards the center in terms of a nominee, or say, okay, if you're going to reject my nominee on party lines, I'm just going to get more ideologically towards my end every time, and we'll just keep playing this game out. So that's the reset button question, and nobody knows how that's going to play out, but that's the one to watch.
Well, we've seen that before, right? That was 1968, right? That was Johnson not being able to get any of his nominees through under Republican Congress, right? I mean, it's messy, but we survive. I mean, in terms of the fights over confirmations, I think it's important to separate two things. We can all be against character assassination of judicial nominees, right? But to say we shouldn't engage in character assassination is not to say we shouldn't have very strong, fierce political and intellectual debates over Supreme Court nominees. Washington was a more peaceful town back when the Republicans would in advance, Orrin Hatch would get together with Bill Clinton and say, let's go with Ginsburg and Breyer, right? Or when Lewis Powell or Scalia would get through very easily. But what we lost in those debates was real thoughtful discussion ahead of time about what the American people want the court to look like, what our elected officials want the court to look like, and to at least have their say at the beginning of the process, because Lord knows we don't get a say after the process.
Yeah, and I think Adam makes a good point. And also, it's not irrational. I mean, as more social policy has moved over to the court and out of the democratic institutions, I think you're seeing more invested in making sure that the bench is filled with people who share their approach to law and society. I don't think it's an accident.
And then there really is no hope, because we're so divided on the proper outcome of that intellectual debate, that philosophical political debate, that really, there can't be anything but this kind of harshness, and it's, a winner takes all, and the loser goes home till the next time when they win. I mean, I just don't see any end to the process playing out the way it is now.
But not to keep jumping in here, but I mean, isn't Justice Ginsburg's whole critique of Roe v. Wade was that officials, in that case the court, stepped in too early, thought they could end a political debate once and for all, and what we saw was the debate bubbles up in other ways. And political debates don't end. I think Bill Buckley said there are no eternal victories, there are no eternal losses, right? These things continue on, and that's probably the way it should be.
So you decide for yourself whether the situation is hopeless or just really bad. I'm going to stand up here so I can see you better, and we'll move to your questions. Who would like to go first? Or would you like to follow the panel in its muted discretion? Yes, Ken.
All right, I'll go first.
There's a microphone for you.
Stand up and seeking the microphone. Okay. Kerry Severino seemed to treat the statutory question in the two ACA cases as cut and dried, but the Fourth Circuit reasoned that references to such exchanges included federal exchanges, and therefore that the statute construed in toto supported the IRS's interpretation. And I wonder what you and others might think about the viability of that argument with the 9 justices, all of whom say plain text is important, also the whole statute is important.
Sure, and for full disclosure, we filed briefs in the King and the Helping cases and in the cert petition as well. So yeah, my position is that the plain text is pretty clear. And I think it's clear that the plain text is at least in tension with the IRS interpretation. The question is exactly that, whether exchange created by the state can mean exchange created by the federal government standing in the shoes of the state. And sure, I think you can argue both ways. This is why the Fourth Circuit was able to come to that position. I think actually you might not even fully get down to there, because some of it does get determined by your approach to discretion and deference and in Chevron. And so a lot of it may get determined by this earlier picky procedural point of, do we have to give deference to the IRS interpretation? So if the court decides, yeah, we have to give deference, they might not even think that that's such a great interpretation, but they're going to have to go with it. And if they decide they don't want to, then I think there's a lot of room to say the plain text just simply doesn't say that. So sure, it's an open question. I think it's very clear. I think the text is clear enough to easily sustain saying this is an unambiguous text and here it is. So, but that obviously, reasonable minds can differ.
Other thoughts on that? It's so quiet in here. Yes, Lee.
Hi. So I guess it doesn't seem quite as clear to me that the court has settled on an approach to statutes as being suggested. I think it's clear in ordinary cases that that's so, but for example, in Bond, I think there's a pretty good argument that there was no statutory interpretation. They just never got around to figuring out what the statute said, except that it didn't reach this case, because if it had reached this case, then they would have had to figure out the constitutional question, and we don't want to do that. So I guess I would worry if I were, thinking about what's going to happen in Holbig, that the statutory approach, the textual approach to statutes holds up, except when it's under a lot of real pressure. And I wonder about that as a possible way of understanding the situation.
Yeah, I agree that I think Bond tells you much more about the court's approach to constitutional interpretation than it does about the court's approach to statutory interpretation. I think it's clear in that opinion, everything was driven by the effort to avoid deciding a very hard treaty power question. And again, I think that traces back to, I think that is the hallmark of the chief's tenure. And whether you agree with it or disagree with it, it is a pretty consistent approach. And we saw it in the Affordable Care Act, we saw it in Bond, we saw it in Northwest Austin. And you're right, Holbig doesn't raise that issue of the constitutional pressure. But at the same time, I also filed a brief in Holbig and King supporting the challenge. I do think the administration's position is fairly complicated, because sometimes they're arguing that, well, this was an intentional gap left in the statute and the IRS filled it. And other times they're saying, well, no, it was an accident. Well, it wasn't both. And so I think they're trying to find out which argument is going to be received better, but they haven't really quite chosen which one they like better.
Mm-hmm. Is this issue going to come up again basically in the Zivatovsky case? Because looking at the statute at issue there, I mean, there is a very strong statement from Congress that the United States policy on Jerusalem is this, right? But the remedy that the litigants, the people who want the passports in that case, what they're asking for is much smaller, right? They're just asking for a passport marked Israel, right? Isn't there a way, I've thought about this case quite a bit. I think it does pose a very, a tough challenge between Congress and the president and their powers. But if at the end of the day, the family just wants a passport, and if at the end of the day the president can say, we're issuing this passport, but U.S. policy remains unchanged, and if at the end of the day the court can construe the statute narrowly to sort of sidestep the question of U.S. policy and just get to the more ministerial question about what something says on a passport, maybe Zivatovsky is another case where the court will try to go for a very minimalist answer. Because I'll be honest, when I look at the case, I sort of step back, and it's hard for me to see what the real substantial infringement of the president's recognition power is. Nobody is actually saying that the U.S. policy on or the statute says this, but in this case, I don't think anybody's saying that U.S. policy is different. It's just a fight over what's written in a passport, which is very important to this family, but it doesn't dictate U.S. policy.
Well, I think that's essentially severing the statement about what U.S. policy would be that is then reflected in this ability to have something in the passport, that the president, and in the judgment of the this administration and previous administrations, actually would have a damaging effect on the president's ability to control, foreign policy and his recognition of the sovereignty, or his decision not to recognize any sovereignty with respect to Jerusalem. So you'd have to both reject the president's judgment, and you'd have to sever the statutory statement about what this means U.S. policy is from the notation on the passport. And I think those are big things to do, and it would be, if the court is willing to say, hey, we're going to discount the president's judgment on this, and not just this president, previous president's judgments, and we're going to ignore what the statutory language says this means, I think that's a very dramatic step for the court to take.
Well, in terms of whose judgment is at issue, I mean, there is the president's, but there's also Congress's judgment of what something should say in a statute. And earlier you referred to the line, I think from, was it Dames and Moore, the president is the sole organ in foreign affairs, and that's a Rehnquist line, and he's drawing from, I think, Marshall, back when Marshall was still in Congress or something like that. But if you look back at where that line originally comes from, I could be mistaken, but I think what Marshall was saying is that once policy is defined by Congress, the president is the sole organ in carrying that out. I mean, you said, I like when you said earlier, sole organ or instrument. Well, yeah, but that's true. Maybe he's the instrument of foreign policy, but an instrument doesn't play itself. I mean, somebody has to decide what the instrument is going to play. So maybe the Senate and Congress should have at least some say of what's in a passport. Or otherwise, we're just going to defer to the president's judgment of what will and will not affect foreign policy.
Right. I mean, and the other thing about Dames and Moore that I think is interesting here is that it's holding, which is that long-standing institutional judgments acquiesced in by Congress over the long term, like unilateral recognition in a lot of instances by the president, should get some deference. So, I mean, I think it's an interesting and difficult case. I'm just saying, I think there are very powerful arguments that the president has that his judgment that this would be very damaging, as previous presidents have also judged, should be respected here.
But Adam does make the sort of intuitive point that it seems kind of trivial. Like, who's going to get upset? The border guard at the Turkish border? I mean, it's...
Right, but the judgment of a number of secretaries of state and presidents has been that that's wrong. It's not trivial. It will be read in a particular way in the foreign relations setting. And the question is, do you just give that the back of your hand and risk having this effect on international relations or not? And I don't know if the court's going to be willing to give it the back of its hand. I think it's a difficult question.
There's one more thing in play here, right? When President Bush signed this statute, he attached to it a signing statement saying, I'm not going to treat this as mandatory, I'm going to treat it as advisory. And that was back when signing statements were a big deal and everybody seemed to be complaining about them. Back in 2008, President Obama was giving his famous interview to the Boston Globe that we all quote now, where he says, I'm not going to use, I actually wrote it down because I knew this would come up, I'm not going to use signing statements to nullify or undermine congressional instructions as enacted into law. And I understand he was a senator then, he's a president now, and his views have changed. But it really seems like at this point, maybe somebody needs to remind everybody about where we've been on these issues.
But it sounds like, Adam, that in this particular case, you think a saving construction, a constitutional avoidance move might be right.
Oh yeah, sure. I'm not saying, like I said, at the end of the day, I'm just very curious why we can't avoid the bigger policy issue and just decide it narrowly on the basis of what's written in a passport.
Yes, sir.
In terms of temperature, like with these events, social events like the border, the agents where rangers are collecting people, what do you think the temperature will be for these cases? Is there going to be like a trend, like football players have pink day, for Susan B. Komen, or what do you think is going to be the trend for this coming term?
I'm not, keep the microphone because I'm not sure we fully have the question yet.
My question is, how is these issues going to affect the citizenship? Will it be more violence, more lobbying, more rioting in the streets? How hot are these?
I think the Facebook case will probably not result in rioting or any significant backlash. But let me ask the question in the most salient way. Assuming the court establishes a right to same-sex marriage, which I think is more likely than not, and more likely than not this coming June, how do you think the country reacts to that?
What makes the question difficult, I think, is there's a sense that attitudes are shifting so quickly. It's, I think we could have answered that 10 years ago and 5 years ago and maybe even last year. But there's at least a sense that attitudes are changing quickly enough that it's hard to venture a prediction. It may make a difference whether the opinion comes down, a year from now or 2 years from now. It's just very hard to know.
Mm-hmm. Again, I think particularly, it may have the effect of kind of ossifying the lines as they are now, or deepening in some cases the split, because if the feeling of this is not what the result I would have come to, makes people, I think, will affect how the shifts go. I mean, it could work both ways. It could mean everyone just jumps on the bandwagon and says this must be the direction everything's going, or people could backlash and say I think the court's stepping out of line. I don't think this is a constitutional question. I think this is something that should be decided democratically, and you could get pushback. So it's really hard to predict. And I think it would probably be different if the court decides it this year versus next year. Who knows?
How much do you think the court does or should care about blows to its reputation, authority, prestige? How much should it care about backlash?
A little bit. Yeah, no, I mean, I think it's human nature for them to care about how their decisions are being received in terms of effects on the other branches and their own credibility. And of course, it's critical that they not pay too much attention to it. We wouldn't want a Supreme Court that's just following whatever is popular and not paying attention to the text and to the history and to the traditional legal sources. So probably they pay a little bit of attention, and that's probably roughly correct.
I mean, it's good that the justices are insulated from this by life tenure. I mean, it's a cliche, but it's true. But this gets back to our earlier discussion about judicial nominations and confirmations, right? I mean, if the justices, no matter which way they go on this case, and no matter which way they go, it's going to fiercely energize at least some corners of the political world. We're going to feel this effect in future judicial nomination fights. And so no matter which way the court goes, it's going to be controversial. And those are the reasons why I find it hard to take too seriously complaints about should the public be fighting over confirmations as fiercely as they do. They fight over these things because these issues are important, and the courts ultimately make difficult decisions for which the public only gets a voice after the fact for future nominations.
Adam, let me answer the question also in a slightly different way. One of the issues in terms of how the court is going to approach statutory interpretation that's come up, it's interesting in the criminal law context in particular. Both the Yates case and the Alonis case raise issues of how broadly to construe criminal statutes. And the court is going to be construing the statutes in the context of a criminal justice system that's going through some really interesting changes. So we have lower crime rates than we have had recently. We've had a dropping in crime rate over the last 20, 30, 25 years or so. I think Eric Holder, Attorney General Holder, recently announced that the size of the federal prison population is dropping this year for the first time since 1980. And also, if you look at the facts of some of the key cases, the Yates case, the shredding fish case, and also the Facebook threat case, there's kind of an aspect of the facts which are almost comical. The fish case being perhaps the lead example, right? So it's Sarbanes-Oxley being applied to a guy who threw some fish into the water. It's such an odd context. The compelling government interest is sort of absent from these cases, and an interesting question is whether the atmospherics either of the facts of the cases or of dropping crime rates in general changes or has some influence on the scope of statutory interpretation. And the contrasting data point would be the 1980s, when crime was very much a pressing political question. Crime rates were high, and you had politicians talking about crime a lot. And in that window of time, you have a series of Supreme Court cases construing, especially in the white-collar context, construing federal criminal laws very broadly, basically saying, this is up to the Justice Department to exercise the Justice Department, the prosecutorial discretion, and the court almost kind of got out of the statutory interpretation game, construing these statutes very, very broadly. And I wonder if now we're seeing with Skilling and Bond and the like, a shift towards narrower statutory interpretation, whether that's reflecting crime rates or some other shift. It's a really interesting trend to watch.
Other questions? So let me ask one that occurred to me as we were talking. The court seems to think, I don't know if this is right, that the public is going to accept a unanimous decision more easily than a closely divided one, which is why Earl Warren worked so hard to make Brown against Board of Education a unanimous case. Does that actually work on the ground? Do people actually care whether Hobby Lobby was 5-4 and the abortion protest case last term, McCullen, was unanimous? Do people care that the marriage case likely to be 5-4 or 6-3 not unanimous? Do these differences that the court seems to care about make a difference on the ground?
I think to some it does, because those who follow the Supreme Court really closely are using certain justices' votes as proxies for what's right and what's wrong. Mm-hmm. So for example, if you're on the conservative side, you might say, all right, I'm going to follow Justice Scalia and Justice Thomas, and whatever they do I think is kind of where I would come out. Or if you're on the liberal side, you might say I follow Justice Sotomayor and Justice Ginsburg. And if they're on board with something, you're probably going to say, well, it must not be that problematic. Whereas if they write a dissent that really sort of is a stirring, you think of a Scalia dissent where he just rips the other side, that's something that can influence people. But I suspect it really influences the 35 legal dorks that are sitting around the room, and or the law professors, many of them here. That's sort of the inside crowd that has a strong sense of, I like this justice, and can you believe that footnote in that opinion? I suspect the public is not really influenced by any of that, because they're not focused. There's a debate out there, but they're not reading the opinions themselves.
Go ahead.
I tend to agree. I think the question is, who are we talking about? If we're talking about court watchers, I think yes. I think for the general public, no. I think how the case interacts with their own life is what matters to them. And you often see that in cases that are less talked about here. The ERISA cases really affect everybody. The tax cases affect everybody. Some of the other cases, are very interesting, but don't really interact with people's everyday lives. I do think, as Kerry pointed out, I do think institutionally, among people who are involved with the court, some of these 9-0 decisions against the administration, I think, do matter. I think you talk about the Appointments Clause challenge, the fact that there was a unanimity on the lead issue. I think that does matter in terms of when they come back to the court in future cases and how they're going to position themselves.
Yeah, I think to just illustrate that it's not always perceived by people the way it is. Take Bush v. Gore, which everyone knows is a very controversial case, but in fact, the main reasoning in it was 7-2. So people have this perception that this was there was one part of the decision that was 5-4, but there's another part 7-2, and everyone sees it as like this is this huge dividing line.
The vote counts. Depends on which side of the aisle you see.
Well, no, it depends on which part of this. 2 parts of the decision, right? So at any rate, there's certain really controversial issues are going to have controversial opinions, but when you have some kind of unanimity, like the NLRB case with the recess appointment clause, at least it does diffuse to a certain extent when you have, for example, Justice Kagan and Justice Sotomayor, who are also voting on the same side. It does diffuse people who say this is it makes it hard to make this is an ideological argument. You can still say this is a wrong result, but it makes it a little harder to.
Mm-hmm. And from the keep in mind the people who have to. The businesses and the people that end up being governed by these decisions, and the lawyers have to advise their clients on them. I mean, a 9-0 decision that doesn't say much at all and sort of sidesteps difficult questions through, very minimalist decisions. There's a lot of virtue to that, but one of the vices is that there isn't a whole lot of clarity for people who have to comply with the law. Whereas a 5-4 decision might cause a political uproar, but at least everybody knows where the court probably stands on a broader principle than just a very narrow decision. So it cuts both ways.
If we've run out of questions, have we? Then I think we'll call it a day. Thank you so much. Please thank the panel.